Assalamu alaikum, brothers and sisters. This is Huzaifa Shahbaz, the Research and Advocacy Coordinator at CAIR National. Welcome you to today's episode of CAIR on Air. Thank you for joining us. We're happy to welcome all of our viewers, including those from American Muslim 360 and those of you who are watching from Facebook and YouTube. Today, we'll be discussing the results of two Supreme Court cases that were announced today. In the first case, the Supreme Court upheld two election laws in the 2020 battleground state of Arizona that challengers said make it harder for minorities to vote. In the second case, in the battle to uphold the First Amendment, the Supreme Court ruled Thursday that charities cannot be compelled to tell state regulators the names of their biggest donors, a requirement that some charitable organizations said would chill contributions. So joining me to have this discussion is Justin Sadowsky, our trial attorney at CAIR National.
Hi.
Thank you, Justin. Thank you for coming on.
Thank you for having me.
So, let's just jump right into it. So maybe with the first case, we can discuss the what happened with the two election laws. So, the first question I think, everyone's wondering about is, can you summarize what had happened in this case and the significance of this case at large?
All right. So the first thing to remember about Supreme Court cases is they're rarely about the facts of the case that's in front of them, right? Like, we all go to court. We don't all go to court, but we go to court and we get decisions that affect us. And those have real lives and stakes. And so the people of Arizona, the voters of Arizona had stakes in this. And I'm not trying to demean them, but when it gets to the Supreme Court, the big issue isn't just that it affects the people in that case, but what it means going forward. So this case means a lot more going forward than it means for the two laws that were being challenged in this case. But the two laws that were being challenged in this case, and they're very different laws. One was a law that would disqualify your ballot if you voted in the wrong precinct, even if there was no meaningful difference between the precinct you voted in and the precinct that you were supposed to vote in. Often the closest precinct to you is not going to be your precinct. So you might have a school next door, and you might think because that school's a voting place and it's next door, that's where you're supposed to vote. And it turns out that's wrong. But unless you live off of a weird boundary, precincts are really small, but election boundaries are fairly large, it'll still have the exact same list of candidates you'll vote for, right? I mean, if you go to the wrong precinct and you walk over a state line, you'd be voting for the wrong senator. That's unlikely to happen if you're talking about the difference between precinct 172 in Detroit and precinct 173 in Detroit. I mean, maybe you'll be voting for the wrong state legislator or the wrong city councilman, but even that is pretty rare. And
right.
But what Arizona says is if you voted in the wrong precinct, all your votes for all your individual, all the individuals you voted for, whether or not you were in the right, whether you or not you had an entitlement to vote for them, is disqualified. Right. That was the first law. The second law, which I think is a more interesting and important one going forward and how it'll affect our community, it was a ballot harvesting ban. And I've lived on a Dene, which is the words what people call Navajos use to describe themselves. I've lived on a Dene reservation for a summer, and so I actually know a little bit about the Dene community. But this was a law which the court denies this, but was intentionally targeted at the Dene community. And what the law did is it banned anyone other than you or an immediate family member from taking your ballot if you voted absentee and placing it in the mail. Mm-hmm. So nobody else could collect your ballot other than you and your mail. And to be fair, there are isolated instances in other states where ballot harvesting has caused a problem because, we see a fraudulent situation where someone who's paid by a candidate, mm-hmm. for instance, will take your mail, and it's possible they may, throw it out. That happened in or change it before electing. That happened very famously in one case in North Carolina, and And that is like one of the few instances of election fraud, which is different than voter fraud. Election fraud is when somebody defrauds the election. A voter fraud is when somebody defrauds an individual vote. And people conflate the two, but they're very different. But like, I've lived on the Dene Reservation. The Dene Reservation is a very interesting place in a very sad way. When I lived there, 25% of homes didn't have electricity. That's now down to 10%. A third didn't have running water. The Dene people make up, I think, 75% of people who don't have electricity in their homes in the country. But they don't live like in the wild, or in just abject squality like you'll see in Africa. In that sense, what they do is they have a strong sense of community. So some people's homes will not have electricity or running water, but they will have access, either private access or public access, to these sort of communal hogans or homes, either other people's private homes that they've opened up to share, or literally like a community will have a specific building. That building will have electricity, it will have showers, it will have television, it will have a kitchen, it will have refrigerators where food can be stored. And these people will be able to live through their relationship with the community. They also will often live an hour to 2 hours from the nearest mailbox. And that's fine for them because, every once a week or so, maybe somebody from the community will go into town, go to Window Rock, that's the main town in the Dene Reservation, and they'll take the mail with them. They'll go out to everyone who's got mail, put in this bag, go there, dump it in a mailbox.
Right.
This law made that illegal.
Right.
And that to me is the bigger problem with the law. But the Supreme Court held in this case is that Section 2 of the Voting Rights Act, and Section 2 of the Voting Rights Act states, and I'm going to read it real quickly, that no voting qualification or prerequisite to voting standard practice or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color. And the language that it uses is very specifically says, which results in a denial of abridgment. And the statutory history and the history of voting in this country, it was in response to a specific Supreme Court said, the design was to make it so that intent did not need to be proven. So long as that resulted in a disparate impact between a racially disparate impact between people in their ability to vote, it doesn't matter whether it facially says black people can't vote, or the secret intent was that to keep black people from voting. Everyone should have the equal access to the right to vote. And then Section B, to support that, says a violation of subsection A is established if. It doesn't say if and only if, it says if. And again, this was response to a specific Supreme Court opinion. Based on the totality of the circumstances, it is shown that the political process leading to nomination or election in the state or political subdivision are not equally open to participation by members of a class of citizens protected by subsection A. That means basically, if you can show that the right to vote isn't equally available to all, then that is one way of proving that Section 2 was violated. And the Supreme Court, I think the majority intentionally sort of reverses this and takes it on its head and says, well, to prove that a rule violates Section 2, you have to show that it is not equally open to all races. And the way you can show that it's not equally open to all races protected by the statute is by looking at the law and saying, on its face, does it differentiate by race? And basically, it made meaningless the amendments that it went back to the Supreme Court decision that the Voting Rights Act was amended to fight, and went back to it as if the Congress intended to ratify that decision, which is not believable. Now, I could have seen in particular the Supreme Court not need to reach this issue as to the Voting Precinct Act. It is true that people of color are 10 times more likely to vote in the wrong precinct than Caucasian people in Arizona. That's what the statistics say. And it's also true that Arizona has about 10 times as many votes disqualified for voting in the wrong precinct than others. But we're still talking about a fairly small number of overall votes. We're still talking about less than 2% of all votes.
Right.
And 2% isn't nothing, but it's not completely aired. And there are ways that you're supposed to catch this. I mean, if you have registered to vote in the past, now this wouldn't affect if on same-day reservation, but I'm not even sure Arizona has same-day reservation. If you went to vote for in the past and you show up at the wrong voting precinct and you say, I'm here to vote, they'll probably look at the voting roll and say, this isn't, you're not registered to vote here. And that might, if you correctly educate people on what to do at this point, then, the voting volunteer, they're typically volunteers, will help you find the right precinct and say, oh, your precinct is, 6 blocks that way, or your precinct is in this gym, because often it's, funnily enough, they'll often have multiple precincts in the same voting place. And so you can literally vote in the wrong precinct, even though you went to the exact right place. But short of a snafu, the system's designed to get you to the right place, even if you voted wrong. Now, of course, as we know, when resources are not distributed equally, what's supposed to happen doesn't happen more frequently for people of color and for more disadvantaged people. But still, we're talking about a small number of votes.
Right. Absolutely. And Justin, thank you for summarizing that for us and really hitting the main points there for our audience. No, it was good. And then, I just have a follow-up. And so what do you think, what kind of precedent does this set for the future?
Yeah.
And what could it mean for voting restrictions?
Yeah. So the stakes in this case were fairly small outside of the Dene Reservation, which isn't, relative to the population of Arizona, again, so many people that it's going to have massive impact on the state of Arizona. But I think we've seen in the news, and you've probably all seen in your states, that pretty much every Republican legislature has started to enact as restrictive and as discriminatory of voting processes for all people, and particularly people of color and people who are in communities that tend to vote Democratic, which, are likely communities of color, in all sorts of ways, ranging from additional ID requirements to not being able to, as you all see the lines in poor areas, there are long lines for voting, and that's not unintentional either, but again, not on the text of the vote, making it illegal to give food and water to people who are online to vote. And the concern is for those which we traditionally would see have violated Section 2, because even though it's facially neutral, it's having a significant disparate effect in minority areas. Because it's facially neutral with a wink and a nod, the Supreme Court's going to let it go. And that's what Kagan's very clear to not just talk about this in the theory, but talk about this moment in history. She says, we're at a perilous point in our democracy. All these laws are being passed, and the court is rewriting Section 2 so that it intentionally turns a blind eye to equal voting rights. And she's absolutely right. Mm-hmm. And so this is going to affect communities of color, including Muslim communities. Thankfully, for our communities, we tend to have a little more resources than the average community of people of color, although that's not uniformly true. And it's going to be a lot of effort by people in the community to make sure that we in the community do what's necessary to help people to vote and get around these discriminatory laws. Because I think the main takeaway from Brnovich is so long as Chief Justice Roberts controls the majority, the courts aren't coming to help.
Right. Absolutely. And thank you for that, Justin. And I think that sums it up pretty well in terms of what this means for our future. I want to transition now to the next Supreme Court case that we heard today, which is about charities and big donors. So in this specific case, Could you talk about over here the significance of the case, and then what is the it attempts to be a First Amendment argument for this? So can you explain that to our viewers and what that means in simple legal terms, so we can understand as well?
All right.
Yeah.
So another 6-3 decision, but this is actually a much less politically decision. And in fact, the Council on American Islamic Relations Legal Defense Fund filed a brief in this case on behalf of Americans for Prosperity. As did the ACLU, we were not alone, supporting the side that won, the side that ended up getting every conservative vote and no liberal votes. And so I wouldn't look at this one as quite through a political lens. And so what this case involved, and the facts matter a little to understand the context, is requirements. California required donor information to be provided by all charities that operate in California, and the information they required to be provided was a schedule that's part of the annual tax form that all nonprofits have to file with the federal government anyway. And so there's this weird issue where no one is challenging that the federal government can collect this information. And the federal government collects this information for a valid reason, which is to confirm that that the tax filing is correct and that the numbers are correct and that the nonprofit's actually acting as a nonprofit and isn't being used as a pass-through for any improper purpose. And California says they wanted a shot at this too because they're worried about California and they wanted the same information. And the court said, no, you can't have it. And the court said you can't have it is because you haven't shown an exacting reason for having it. And it's unclear whether they are really holding the state of California to an exacting standard, because the facts here aren't particularly great for California, which is they've never ever used this information that they collect as part of any investigation or ever successfully use this information, which they've collected for years, to shut down an improper nonprofit. So they're collecting this information and they've got this reason they claim they need this information, but they've never used it for that reason.
Okay.
And we at CAIR are very concerned when the government collects information on us for very important reasons, which is because the government has historically used that information, especially in our communities, to hurt us. And we're not the first people. We're not the first community that the government has done that to. I mean, a lot of these cases that you'll see discussed, if you read the opinion, come from the 50s and 60s and have the word NAACP as one of the parties, because a lot of the precedents are issued harken back to the civil rights era when people were collecting information on the NAACP in particular in order to punish people who belong to the NAACP and to punish the Black community more broadly. And we've seen people who pray at the wrong mosque or have studied Arabic at the too much. We've seen them put on watch lists, and we've seen their rights be taken away from them. And so that's why we filed a brief in support of RFP. We're concerned about the government having this information. Now, our biggest concern, I think rightfully so, is the government misusing this. The court talks mostly about this as the government improperly disclosing this information to private users who, and that has a way to chill speech. So we're talking about the freedom of association. There's 5 freedoms of the First Amendment: speech, association, petition, the religious clauses. Right.
And yeah, absolutely. And I think you mentioned a very important point about the the right to privacy and the terrorism watch list, and how a lot of this data can be misused and abused to hurt the Muslim community. So, this is my last question for you. So what does this mean for, terrorism watch list cases, for example? What is the worst case scenario? What could possibly happen?
So if you can hold the Supreme Court to its word in this case, and that is a giant if, this would be really helpful to challenging the watch list. I want to just quote one sentence from this opinion. Hold on, I just got to pull it up, which is, our cases have said that disclosure requirements can chill association even if there is no disclosure to the general public. And the reason why that's important is there's a back and forth between the majority opinion and the dissent in this case, where the majority opinion is saying that the very possibility that the government might improperly use this or disclose this information makes it illegal for them to collect this information. And the dissent is saying, no, wait, for somebody, usually to sue, somebody needs to be harmed. And so long as the government has not used this information improperly or improperly disclosed it, why are these parties even here complaining? They don't have standing.
Right.
And this standing issue about improper disclosure has actually, one of the reasons the Fourth Circuit reversed the district court finding the watch list unconstitutional and ruling the watch list wasn't unconstitutional is this exact point. The court said, we haven't, even though the government's collecting this information and could use it improperly, we haven't shown that all the plaintiffs have suffered harm from this disclosure. And I think that was wrong on its facts, for one. And I think it was a results-oriented decision by a judge known for consistently siding with the government. I may be biased, but it's very contrary to this. You don't have to show it because it still can chill association, even if the government ultimately doesn't misuse the information. The problem I'm having is that I don't think the government's going to consistently apply this rule outside of laws that the political conservative groups don't like. And the reason why I say that is a few weeks ago, the Supreme Court decided another case called TransUnion. And TransUnion involved the negligent acts of a credit reporting company that managed to accidentally flag people as criminals on their credit reports. Right. The question was, is some of the people that were, the Congress said that whether or not can show injury from a false statement of fact on your credit report, you can sue and receive what's called statutory damages. So like you get $100, let's say. And the Supreme Court said for those people who actually haven't shown that they were harmed by the misstatement of the credit reporters, don't have Article 3 standing. They can't come into federal court and complain because there's no controversy. Now, that doesn't say anything about state court, so people might still be able to bring their claims in state courts, but it's saying that you can't show injury unless you can show harm, which is the opposite of what they've said in Americans for Prosperity. So which is it? And I think the only way I can harmonize the two cases is cynically, to be honest, to say, if the Supreme Court likes the law in question, then you don't have to show injury. Showing the potential for injury is enough. If it doesn't like it, well, then we're going to make it harder on you. And our concern is that, this court might be hostile to the Muslim community and hostile to Muslim to watch list claims. And so I'm not sure we're going to get the protections that seem promised to us in Americans for Prosperity.
Absolutely. Well, thank you very much, Justin, for a very informative discussion. You hit all the main points. I think our audience really enjoyed it. I want to thank you again for coming on to our show, and it's a pleasure having you. And I would like to thank our viewers for joining us on CAIR on Air. CAIR on Air, as a reminder, runs every Tuesday and Thursday at 3 o'clock Eastern Time. And we look forward to having you all next Tuesday. Until then, Assalamu alaikum and be well.